You're watching The Legal Breakdown. Glenn, with the D.C. prosecution back in Judge Chutkan's hands now, she's actually moving way faster than Trump had anticipated. Can you explain what she just did in that D.C. courtroom?
Yeah, Brian, Judge Chutkan is moving at light speed within about 24 hours of having the Supreme Court give her Donald Trump's prosecution back to move out. She has denied not one, but two Donald Trump motions to dismiss the case. And she also put them on a very short leash. She wants the parties to submit their proposed schedule within about a week, and then she is hauling them into court. I'll be in court observing the proceedings on August 16th. And that's when she's going to set the schedule and move in the direction of evidentiary hearings. That, Brian, is when we will begin to see presumably a whole bunch of evidence that Jack Smith developed in the grand jury from Republican witnesses about the crimes of Donald Trump, because Judge Chutkan is going to have to sort out, okay, of all of these criminal acts Donald Trump undertook, which one might be official presidential acts? Hint, not many of them. Which ones might be unofficial or private acts, in his capacity as a candidate designed to unlawfully retain the power of the presidency? I would say most of them. But, this is going to be an evidentiary hearing literally like no other, certainly no other that I have seen in my 30 years as a federal prosecutor. But more concretely, here's what she just did. First of all, she denied a Trump motion to dismiss based on presidential immunity generally. She summarily denied that. She didn't even issue a written ruling. But then a second order that she issued on Saturday, and let me tell you, Saturday, courts are closed. Saturday, you usually don't find judges in their chambers toiling away, but that is precisely what Judge Tanya Chutkan has been doing. And she just ordered a 16-page opinion saying, no, we're not dismissing Donald Trump's case based on a claim that he's being selectively prosecuted. But it really highlights how Donald Trump fails at every turn to support the BS claims he is forever making in the public square. I promise I'm not going to turn this into a legal breakdown law school class, but let me just set it up for you before I read just a line or two from what Judge Chutkan said. Donald Trump said he's being selectively prosecuted. What does that mean? Well, that means that all of the other people who committed similar crimes and who are similarly situated to Donald Trump, the defendant, have not been prosecuted. They've all been given a walk, and it's only Donald Trump who is being prosecuted unfairly. They've singled him out and they've discriminated against him. Well, Brian, first of all, that argument it collapses under the weight of its own foolishness.
Wait, weren't there 1,000 January 6th defendants who were charged and indicted?
I mean, think about it. In our nation's history, pretty much every single president has tried to criminally overturn the results of the presidential election. We've never had a peaceful transfer of power. Let's back up. It's the exact opposite of that. So that's why I say this was an easy motion for Judge Chutkan to deny, because it's frivolous on its face. It's literally laughable. But if you are going to try to prove selective prosecution, very briefly, it's a two-part test, and the defendant has to prove both parts. Has to prove that the prosecution was motivated by a discriminatory purpose and that the prosecution had a discriminatory effect. And early on in her ruling, Judge Chutkan says, Donald Trump proves neither of the two required parts of that test. And here is my favorite line or two from Judge Chutkan's opinion, and it has to deal with her rejecting Donald Trump's claim that there was a discriminatory purpose in this prosecution against him. How does he go about supporting his claim that there was a discriminatory purpose? Believe it or not, Brian, he attaches two news clippings, two news articles to his legal filing. Here's a spoiler alert. News articles are not evidence, but that's what Donald Trump uses to try to prove his claim. And the two news clippings, which are not evidence that he attaches, here is what Judge Chutkan says about them. The news articles defendant Trump submitted do not establish that his prosecution was improperly motivated, but even more fundamentally, defendant Trump misreads the articles. So even the non-evidence Donald Trump cannot, get it right. It is laughable. It is absurd. It is exactly what Donald Trump does in the court of public opinion every day. But when he does it in a court of law, he gets the crap smacked out of him, figuratively speaking, by those judges who are sort of honest judges of the facts and the law. And that is exactly what Judge Chutkan just did.
So just to clarify here, I know that we're waiting for some adjudication of the issue of whether the Supreme Court's immunity ruling applies to the charges that Donald Trump is facing in the D.C. prosecution, but that's not what we got here. We haven't started with those. These were just pending motions to dismiss that Judge Chutkan was sitting on, and then the second that she got this trial back in her hands, she was able to hand down the responses to those motions immediately.
Brian, you're exactly right. There were a number of motions to dismiss filed before the Supreme Court grabbed hold of the presidential immunity issue and put a stop to the trial court proceedings. So I am quite sure Judge Chutkan had this 16-page denial of Donald Trump's motion to dismiss based on selective prosecution ready to go. And once she got the case back in her hands, she instantly issued the ruling. But as you say, we are waiting for what I think can accurately be called a mega hearing, because what's going to happen is every single act, including every single criminal act, and there are many that are included in the indictment against Donald Trump, they're going to have a hearing. And Judge Chutkan will have to determine whether each and every one was an official governmental act, something Donald Trump did within the scope of his official duties as president, or whether each act is an unofficial act. An act basically of a candidate who is desperately trying to cling to power after he had been voted out of office. The reason I say this is a motions hearing unlike anything I've ever seen, this is not the kind of endeavor we typically go through. We as prosecutors have the grand jury issue an indictment, and then we move into the trial proper. We don't often litigate each and every criminal act of a defendant to see whether some kind of privilege or immunity might attach. But this is a singular and unique prosecution, and given the horrific unconstitutional opinion by the Supreme Court that a president is basically king light, right? He gets a pass for most conduct. This is something that we've never seen litigated before, and I intend to be in the courtroom each and every day watching this one unfold.
Glenn, I know that we will have the opportunity to at least have these issues, aired out in full view of the public, so to speak, because there will be reporters, including you, reporting out what we hear. But is it possible that at the end of the day, these issues will be adjudicated by Judge Chutkan, go to an appeals court, and could very well end up at the U.S. Supreme Court? And this is the same Supreme Court that allowed this bogus notion of presidential immunity to stand in the first place. And so logic might suggest that they would also rule in Trump's favor if and when this issue got to them. So is that something that could possibly happen, that we can go through this whole process and then only to watch it eventually get to the Supreme Court and then
Brian,
just rule in Trump's favor?
I think you're exactly right on the procedure, because think about what happened. Donald Trump raised presidential immunity. And mind you, there was no law, there was no precedent, and there is no constitutional provision supporting his claim that presidents are immune from being held accountable for the crimes they commit against the American people. It's mind-blowing just to think about it. And the trial court, Judge Chutkan, had a full hearing, and she issued an authoritative ruling. No such thing. That went up to the D.C. Federal Circuit Court of Appeals. 3 excellent, experienced federal court judges said, no, it's not a thing. And it's only, Donald Trump's friends, some might even go so far as to call them criminal associates on the Supreme Court, the radical right-wing bloc, made it up out of whole cloth. They contradicted the very language of the Constitution in doing it. And what you just described could happen all over again. Think about it. Judge Chutkan could have this mega hearing. She could rule, no, the vast majority of these acts are private conduct, not official acts of a president. Therefore, he has no immunity. The D.C. Federal Circuit of Court of Appeals could affirm that ruling, reaching the same conclusion. And here comes Donald Trump's friends like Alito and Thomas and Gorsuch and Kavanaugh and Barrett and Chief Justice Roberts. And they could say, you know what? All of the lower court judges got it all wrong again. We're going to give him immunity for everything. That, unfortunately, is a distinct possibility.
Okay, well, that kind of underscores the importance of this upcoming hearing, with this mini trial we've been calling it, where we're going to at least, again, put this in full view of the public and at least give the American people the opportunity to hear out what's happened and what the charges are against Trump and a lot of the evidence against Donald Trump, so that the voters can make an informed decision before we all head to the polls this November. So that, again, underscores the importance of what we're about to see. Just real quick, Glenn, when will that take place?
So the hearing is scheduled for August 16th. I don't know if it's going to be a one-day hearing or if it's going to linger into the following week, but that will basically be a ground rules hearing. What are we going to cover? How are we going to cover it? Are we going to hear from live witnesses, or are we going to rely on transcripts? So that will be basically hashing out exactly what this mega hearing will look like. And then I have a feeling Judge Chutkan will set the hearing itself, the evidentiary hearing, on the calendar very quickly or very soon after that August 16th hearing. And let me just emphasize, Brian, we just talked about this horrible scenario where this could all be for naught because it could go up to the Supreme Court and they could do Donald Trump yet another solid and extend presidential immunity to cover everything he did. And that's why, as we've discussed before, we were never going to be saved by any one prosecutor, any judge, any appeals court, any politician, or anybody else. We are the ones who get to go to the polls and save ourselves by voting against Donald Trump on November 5th for Kamala Harris in the event she's the nominee. And most importantly, we get to cast our vote as jurors that Donald Trump is in fact guilty of these offenses. And we can do that by voting against him on November 5th.
Perfectly put. Couldn't have said it better myself. With that said, we will, of course, stay on top of this case, this trial, as it continues to play itself out and heads toward this mini trial that we're going to see in D.C. So for those watching right now, if you want to follow along, please make sure to subscribe to both of our channels. The links are right here on the screen. I'm Brian Teller Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.